Welcome to the Generis Show, your unique perspective on everything you need to know about your civil rights and the criminal injustice system. With Erica Merrill, I'm attorney Brian Jones, criminal defense and civil rights warrior. Today in segment 1, we'll be discussing two major court decisions, one out of the Georgia Supreme Court and one out of the United States Supreme Court, addressing unlawful arrest and Fourth Amendment search and seizure protections. We're also going to be looking at the brand new mobile breath testing unit operated by the Columbus, Ohio Police Department. In segment 2, as promised, we'll be wrapping up our 5-part series on field sobriety testing, looking at non-standardized field sobriety tests. Make sure you don't miss an episode by subscribing on Apple Podcasts, Spotify, and YouTube. Follow us on social media and look to the law office of brianjones.com for everything you need to know about your civil rights and the criminal injustice system. So Erica, did you see in the news this week that the Georgia Supreme Court has issued a ruling stating that it is lawful to use force to resist an unlawful arrest?
Yeah, I did. This is unbelievable. It's like first people were angry about all of the violence that has been happening for the past few years and has been very prevalent in the news. And I know it's been happening for way longer than that, probably since time began. But now there are going to be rulings that allow you to fight back for unlawful arrests. How amazing. Can you tell us a little bit about how this case came to be on appeal to the Georgia Supreme Court?
Sure, Erica. So back in 2018, a fellow named Chris Glenn was walking home inside of a line of trees that were kind of an informal line of the outside of the property of an elementary school. Somebody called him in as a suspicious person, and when the police show up, they tell him that he's being detained, which everybody would feel like they were under arrest at that point. And after being cooperative and trying to explain his situation and getting nowhere with the police officer, Mr. Glenn starts resisting. And once he's subdued, he ultimately kicks out a cruiser door and causes a variety of other property damage to the cruiser. He's charged with a variety of counts, including resisting arrest. And his public defender raised the argument that he was legitimately allowed to resist because the officer had no reason to arrest him in the first place. And he's allowed to use a reasonable amount of force in resisting that arrest. So the case works its way through the trial court. It works its way through the intermediate appellate courts, and now it's landed on the desk of the Georgia Supreme Court, where the Georgia Supreme Court has now said, based on common law, there is a right to resist a lawful arrest. And that was the controlling factor in the court's decision.
Wow, I've never heard of this before. I mean, I've heard the term common law, but I just figured all the laws were common laws. Can you tell us what the difference is between the common law and the rest of the laws?
So the distinction is common law versus like statutory law. So statutory law is what you see in the code books, the Ohio Revised Code, the United States Code. Common law is the body of law that comes from case decisions over the course of time. All law really originates in the common law, and the laws of the United States originate in the common laws of England. So over years and years and years, judges and magistrates would write down what the rules of living in a civilized society are in the form of court decisions. And those decisions are based upon one another. And similarity and consistency are really important concepts in the law. And so that common law tradition, that tradition of using the same rules and applying them over and over again and reconsidering them under appropriate circumstances is the common law. Now, common law is relevant to cases where the outcome can't be decided just looking at statutes or written rules as far as like the rules of evidence. So the common law becomes important when a case can't be decided just on statutory interpretation or looking at the rules of procedure or evidence, for example. Now, there are 8 states where there are laws that impose a duty to submit to even an unlawful arrest. Georgia is not one of those states. And so the statutory law in Georgia is silent on this. So the common law right to resist an unlawful arrest remains in full force and effect. This is the standard Ohio uses as well. So you are allowed in Ohio to resist an unlawful arrest. But be careful, because if you're wrong and the arrest was lawful, you've now added a new offense to your stack of allegations.
That sounds really complicated. Like you're making big decisions in the middle of a crazy situation. You've got to decide whether it's lawful or unlawful. I have this comedy in my head where the police are trying to arrest someone and the guy turns around and says, "No, you're unlawful. No, you're unlawful." And who decides whether this is lawful or not?
Well, ultimately, if a citizen makes the decision to resist an arrest, a judge or a jury is going to decide whether the arrest was lawful in the first instance. In the moment, the officer makes a decision to arrest a suspect. And the officer has to make that decision by deciding that he or she has probable cause to determine the arrest is lawful. So a reasonable belief held by a person of ordinary intelligence that a crime has been committed and that a particular person committed that crime. That's the standard for probable cause. Now, probable cause is typically determined by a judge, and according to the Fourth Amendment, must be decided by a judge. But there are a variety of exceptions to the Fourth Amendment, which we're going to talk about in our next story. But for this particular situation, out in the field, officers can and must make those decisions. Now, at the end of the day, like I said before, a jury has the power to decide if the person resisting an arrest was resisting a lawful or an unlawful arrest. And were they using proportionate and appropriate force necessary to resist? So a suspect can't use lethal force to escape from an officer who's using non-lethal force to detain him.
So the force has to match, which ironically is not what's been happening in these cases we see in the news where people are getting seriously injured or even killed by the police for carrying a sandwich into a children's party, or like any of the other situations that we brought up this year. It's been amazing. I'm glad that there are some reminders that you can actually protect yourself if something is going wrong, and that you don't have to just listen to the police if they are in fact doing something wrong and it's going to hurt you.
Erica, and I think you touch on something that we've mentioned on this podcast several times, which is the use of de-escalation tactics, the notion that police can do their job without imposing violence on citizens is not only an issue about the safety of the people, but it's an issue of the safety of the police as well. Because what we have here, what we've identified with this particular story, is that proportionality response. So if an officer pulls his gun on a citizen and that arrest is unlawful, according to the law, the citizen is allowed to then use lethal force to prevent that unlawful arrest, or I suppose more accurately, that unlawful seizure in the guise of being shot. So this becomes an officer safety issue as well, which is why we advocate all the time for officers to learn de-escalation tactics, to remove police from situations that they're not properly trained to be in. Mental health situations, drug overdose situations, situations where a social worker is more suited to the job and more appropriately responding to the situation.
I agree with you. And, I'm glad for this education. The fact that you do this show every week, and we're actually approaching our 50th show soon. I believe that this one is 47 or 48. We're getting up there, and like every single one of these shows, we are educating the public on their rights and how to act, and really ideally how we'd like to see the world be, because what's happening now is just scary and out of control.
Well, you're absolutely right, Erica. And I think one of the ways that we can do that is by continuing to educate both sides of the debate on the benefits of moving towards a nonviolent resolution to the conflicts between the government and its citizens. Now, one of the rules that dictate and limit the conduct of the government as it relates to the citizens is the Fourth Amendment to the United States Constitution that prohibits warrantless searches and seizures. The United States Supreme Court has issued a decision interpreting the Fourth Amendment and has ruled that police cannot search homes without a warrant in the name of the community caretaking exception to the warrant requirement. So did you see this story in the news this week, Erica?
Yeah, I mean, this is unbelievable. We've seen a lot of crazy things happen without warrants, where people just feel like, where the police maybe even enter the wrong house and kill somebody, and the whole thing didn't need to happen. And I don't know, is that because of this particular rule? So is that why they could go into Breonna Taylor's house, for example, because they felt like they were taking care of the community caretaking?
Well, so Breonna Taylor's case, there was a warrant. There was a
Okay.
warrant to search her house. They didn't knock, and they never checked on the accuracy of the information. They got lies from a snitch, and they never confirmed the snitch's lies were truthful, and they weren't, and now Breonna Taylor's dead.
You
So
gotta
they
check
had
your
a
sources.
warrant in that circumstance.
Ah, I see. You know, we do so many of these. It's hard to remember all the details of all of them, but the end result is never good if people are not careful. So tell us about the circumstances of this particular case.
Sure. So this case originated out of Rhode Island. A man filed a lawsuit against the police after officers searched his home and took 2 handguns, and they didn't have a warrant for those. They seized them, wouldn't give them back to them. There was the origination of this was he and his wife had an argument, and she left, and she tried to call him to check on him, and he never answered her phone calls. So she got worried that he was suicidal. And so she called the police to go out and just do a wellness check on him. And on making contact with the police, he was sitting outside on his porch. He agreed to a psych evaluation, and he said, I'm willing to go with you guys. I'm fine. If you want to get a psych evaluation, that's fine. But I don't want you going in and taking my guns. These are my guns. I have a right to keep them, and you can't take them. And the police agreed. They told him, "Yep, that's fine. We're not gonna do that." And then lo and behold, of course, they took him to the psych evaluation, and they went in and took his guns without a warrant.
We've kind of covered in the past that police lie, and they can lie to get what they want done. So I'm not surprised that they said they weren't going to take the guns and then they took them. But I mean, my question to you is, can you just review this community caretaking exception?
Yeah, so remember, we start with the Fourth Amendment. And the Fourth Amendment says that the police, the government, can't search you or your property, and they can't seize you or your stuff without having the reason to search or seize reviewed by a neutral magistrate or judge. And the way that happens is through the request for and issuance of a warrant. So the warrant has to be supported by probable cause. That probable cause has to be determined by a judge or a magistrate. And if the police can convince a judge or a magistrate that there's probable cause, then they get a little piece of paper and they can go out and they can grab you and they can haul you off to jail, or they can search your house, they can search your pockets, they can search your car. That's the rule. And what's happened over the 200 plus years that America has been in existence is that there have been a variety of exceptions to that rule carved out. And the community caretaking is one of those exceptions. It was created in 1973 in a case called Katie v. Dombrowski. Now, in that case, a police officer took a gun out of an impounded car without having a warrant. And what the Supreme Court said then is that the police are allowed to conduct these kinds of searches without a warrant if they're just taking care of the community. If there's a reason to do it that is in the community's best interests, or to keep the community safe, then the police don't have to comply with the warrant requirement. They don't have to go and get a magistrate to check off on it. They can just search your property or seize your person. This is the same reason that the police say can take somebody who's experiencing a mental health crisis and haul them off to a hospital to get a mental health evaluation. They don't get a warrant to do that, and the person's not under arrest. They are using the community caretaking exception to the warrant requirement to seize or detain the individual and then take them to get the health care that they need.
Wow, that is so interesting. I always learn something new or several things new on these interviews. So, what is the difference between the caretaking exception and the exigent circumstances?
So the community caretaking involves an action that the officer is already engaged in. So, impounding a vehicle that doesn't require a warrant. So the warrantless search is a natural extension of that. The vehicle inventory exception to the warrant requirement is kind of a subsection of the community caretaking exception. Now, this exception, the community caretaking exception, does not apply to searches of homes. And the exigent circumstances exception would allow the police to enter a home. And the exigent circumstances require an emergency, an injured occupant, the need to protect somebody from imminent injury. So, something really terrible is going to happen. And if we don't stop it right now, it's already happened and we can limit the consequences of it, or it's about to happen and we can prevent it. That's the exigent circumstances exception. Now, the exigent circumstances exception didn't apply in this case because there was nobody in the house. The man had already been removed from the property when the officers chose to go into the house without a warrant. So at that point, him being removed, the officers had the opportunity to go to a judge and say, this is our probable cause, which, in my review of the circumstances, I don't think exist in this case. Certainly not probable cause to go in and seize the firearms because there's no crime going on. Maybe the state of Rhode Island has some sort of red flag rule where if you get a mental health evaluation, your weapons can be seized. But again, that should be reviewed by a judge or a magistrate. And they had every opportunity to do so because the man had been taken to the hospital.
Well, too, I mean, who's to say? I mean, he and his wife were having a fight and she's just getting back at him by calling the cops and saying, hey, he's got guns, and just knowing that that's going to piss him off.
Exactly. There are a variety of reasons why this might, come to exist. And that review of a neutral person is critically important. I don't know if you've ever had the experience, Erica, of turning on, a sporting event and not having any allegiance to any of the teams playing, but, you're just watching the game, and over the course of the contest, you start to root for one side over the other for no particular reason that you can identify. And police, being human beings like any of the rest of us, tend to have rooting interests, and those rooting interests tend to lie in the side of the person that gets to them first. So having that neutral party in between the partisan, biased, favorited parties and the violation of our constitutional rights is critically important.
I mean, that's true. I love that example that you're giving. It's just, I mean, I've heard attorneys that I interview say, hey, sometimes the judge may not even like the sound of your voice, like you just don't know why they would side with one or the other. It could be anything. It could be something in their subconscious that they just they had an experience with someone that looked like you that they hated, like it could be anything.
It could be anything on behalf of the judge or the police. Remember, the police are actors in this situation as well. Everybody has their own biases. So yeah, that's again why the neutral party is so important. So Erica, did you see in the news this week that the Columbus Police Department has deployed new countermeasures in the war against OVIs, a mobile breath testing vehicle?
What? This sounds insane. Uh, um I don't know why. It just, I mean, how is this vehicle going to be put into action?
So officers will be able to request that the testing van be deployed to their location at a traffic stop or a crash where a driver is suspected of drunk driving. The van has a breathalyzer machine, it has the ability to collect blood and urine samples, and it has pre-testing facilities inside the vehicle. So that urine sample can be supposedly analyzed right there on site. The van is also equipped with cameras that record the interior of the vehicle. Now, before this vehicle existed, officers had to transport people to the downtown Columbus breath testing machines or a hospital or a substation to collect urine samples, or out to a neighboring suburb in order to use their breath testing machine. But with this mobile breath testing unit, they can bring the machine to the suspect. Now, the funny thing about this is, Erica, is that about several years ago, maybe 4 or 5 years ago, Ohio purchased the Intoxilizer 8000. And the big selling point of the Intoxilizer 8000, which is I call the breath testing lunchbox because it looks like a lunchbox, it's literally got a little handle on it, is that it's mobile and it was supposed to be able to be used by officers in the field. And yet they don't use it for that purpose. And that's a whole other bag of worms that we're going to address in a future episode. But now, CPD at least has this mobile breath testing van or this mobile chemical testing van to use.
That is so interesting. It sounds expensive too. I mean, does this vehicle setting affect the reliability of the testing machines? I mean, I can't imagine all of the potholes that they go over is going to help the reliability.
I think you're hitting right on the major problem with this new device. Number one, the breath testing equipment is a delicate intermingling of computer software and mechanical parts. And as the vehicle drives around over the course of time, that device is going to get out of tolerance. Now, you've heard me say it before, and I'll say it again. Blood testing is the best chemical testing that there is when it's done correctly. And that when it's done correctly is critically important because while blood testing is the most accurate, it's also the easiest to screw up in the process of extraction of the sample, storage of the sample, and testing of the sample. Now, when it's done correctly, it's fantastic. But to do that extraction in the field is incredibly difficult. To do it accurately and professionally and without causing undue harm to the person the sample is being extracted from is even more difficult. Now, the fact that the testing will be done more quickly rather than having to travel, 20, 30, maybe even, 45 or 60 minutes to reach a machine will absolutely have an impact on DUI cases in Columbus as well. I think the results from this mobile unit are going to receive a special level of scrutiny from the Central Ohio Defense Bar.
Oh, I bet they are. I bet you're going to have a lot of fun in the courtroom with this one, just throwing out the results because they're probably not going to be accurate. After a while, anyway. I mean, it's really hard to say, but even that's why with shipping computers and sensitive equipment, they have, so much packaging. It's not really meant to like bounce around constantly. It's that doesn't sound like a good recipe. How are they paying for this new toy?
The unit was paid for as a result of a grant from Anheuser-Busch, the people that make Budweiser and Bud Light beer. The federal government and private agencies often provide grants for this kind of equipment, riot gear, military response vehicles, bulletproof vests, fully automatic weapons, all the fun toys that the police get to play with. Police departments are public agencies and are eligible for a variety of these grants. But that doesn't mean that these gifts of equipment or cash don't come with expectations or strings attached. So the strings that are attached to this grant will be something else that we're going to want to continue exploring. There is no irony lost on me that a company that makes intoxicating substances is providing a tool to accuse people of driving impaired.
I mean, that's kind of like all the cigarette companies paying for asthma treatments and um, smoking cessation classes and the rest of it, but yet they're providing the drug.
Well, yeah, I think you're right. And more accurately, providing smoking cessation tools with the string attached that your personal information gets turned over to them, or with the string attached that they're going to get you addicted to some other substance. What is the catch that comes with this money?
I mean, that's true. They could make a lot of money off of the drugs and the anti-smoking gum and all that stuff. And I'm sure that we're going to see this sort of thing with alcohol.
For sure. Staying on the subject of impaired driving, Erica, let's look at part 5 of our 5-part series of the National Highway Traffic Safety Administration's field sobriety testing. And this day, we're going to step outside of the manual and look at non-standardized tests that are both in and outside of the NHTSA manual.
Non-standardized tests. Wow, I just assumed that they were all standardized because they're doing them. So what are the non-standardized tests for field sobriety?
So there's the tests, the type of tests are as varied as there are officers out there. You may recall from prior episodes, I talked about an officer taking a handful of coins and throwing them on the ground and saying, pick these coins up in a smallest to highest order, which is interesting because would you pick that up penny, nickel, dime, quarter, or would you pick it up dime, penny, nickel, quarter? It's confusing. This is the reason why we have standardized tests. Standing with your feet together and tipping your head backwards is a typical non-standardized test that officers think measure an individual's balance and coordination. Counting the number of fingers that an officer raises, reciting a portion of the alphabet, and the officers love to say, start at E and end at W, just a portion, or start at B and end at R. Just to try and make things a little bit more difficult. They also like to say you're not allowed to sing the alphabet when they do the alphabet test. Counting backwards is mentioned in the NHTSA manual. The alphabet test is mentioned in the NHTSA manual, but there's no standardization to it. Counting backwards, and what they require you to do is go over and past two tens jumps. So count backwards from 63 to 47. So you have to go from the 60s to the 50s and the 50s to the 40s. And you have to remember where to start and where to stop. Standing and tilting your head back and holding your hands out to the side and touching your nose while you're doing that, or closing your eyes and touching your nose with a finger. Sequentially touching your fingertips forwards and backwards. All of these, imaginary measurements of dexterity are things that officers try to use on the side of the road to determine if you are impaired or sober.
What else are they going to add? Do a one-handed push-up and play with a monkey? I don't know. Like, it sounds insane.
Well, they never cease to amaze with their creativity and, insanity.
Well, they have a lot of time to sit around in their cars thinking of these things. So I suppose we're looking at hours of boredom, and they finally get something exciting to do, and it's fun. These people are doing whatever they say, and some of them might be slightly impaired. So I don't know. I guess.
It's like a high stakes game. Sorry, Erica, go ahead.
No, go ahead. I mean, I guess that's the motive. I'm not sure why they would have these really crazy non-standardized tests happening.
Yeah, it's like a high stakes game of Simon Says.
I think so. It could ruin your life at the end if you get it wrong, and you never know what they're going to say next. So why would they use these non-standardized tests versus the more reliable tests that exist?
Well, one of the problems with the standardized field sobriety tests is they're not reliable. They're not standardized for people that are over the age of 65, for people that are more than 50 pounds overweight, for people with a disability, a temporary injury, or a medical condition, people that have prosthesis, people that have, diseases such as cerebral palsy. The tests are common in the United States because the purpose of the field sobriety testing is to establish probable cause to then lead to an arrest and invoke the implied consent law, which requires drivers who are arrested for OVI to either submit to a chemical sample or face losing their license. The tests can also be used to extend the interaction between the police and the citizens, which increases the officer's opportunity to observe impairment and list clues to support his or her probable cause allegation.
Are the non-standardized field sobriety tests admissible in court?
So they're not standardized. So they're not scientifically reliable. And Ohio courts they use them in some ways. So the courts allow them into evidence under a totality of circumstances standard that the officer is allowed to consider when deciding to arrest. They can be used as observations of the officer in front of a jury for the jury to decide proof beyond a reasonable doubt. And because of this, because they're not standardized, and because the officer isn't allowed to testify to specifically what they're looking for in these tests, it's just, well, here's this person doing this thing. We want you to think that they're impaired because they're not doing it perfectly. They're really difficult to challenge. That lack of standardization really gives the officer a lot of squishy wiggle room to say, after the the attorney gets them pinned down and say, well, that's not really the cue that I'm looking for. It's this, or, well, you're not really describing it correctly. It's more like that. And it gives the police an opportunity to be really, really fluid with their testimony on the witness stand, because each individual officer is making their own subjective determination and suggesting that the judge or the jury should reach the same opinion. Now, these tests can be challenged on the basis of all of the characteristics that we've talked about before. So drivers that have inner ear or balance issues, physical impairments, things like high blood pressure or other diseases can all be reasons to challenge these tests in front of a jury, less successful in front of a judge in a probable cause type situation. These are some of the most difficult tests to challenge. And that's the reason the officers try to use them in almost every case. And you should absolutely refuse to do these parlor tricks. The standardized field sobriety testing, what I call balance and coordination tests, at least there's a set of rules. It's a losing game. It's a stacked deck and you're gonna lose, but at least there are rules to the game. With this, there are no rules. When my children were very young, we used to play a game and they like to call it I win. And so, we would have an interaction. We would flip over some cards and they would look at the cards and they would say, I win. And they would take all the cards and then they'd lay out some more cards and we'd look at them and they'd say, I win. And it didn't matter what cards were flipped over, what cards I had, what cards they had, didn't matter suit, rank. It was just, they win. And with standardized field sobriety testing, balance and coordination testing on the side of the road, it's a game of the officer, like my toddler child playing, I win.
Well, that is certainly hilarious. I can see you doing that too. And to even think of the officers doing it this way. I mean, you're right. Let's just see what you can do and see if you do what I want you to do the correct way. I mean, it seems crazy.
Erica, thank you for joining me in this discussion. For everybody out there listening, thank you for being dedicated to expanding your knowledge of your constitutional rights and gaining a little bit of understanding of the criminal injustice system. To continue that education and learn about the latest decisions from the United States Supreme Court and courts all over the nation, holding the police and the government accountable for their misdeeds, roadside balance and coordination testing, and everything related to your constitutional and civil rights, look to the law office of brianjones.com or find us on our social media channels, facebook.com/Central Ohio Criminal Defense and @TLOBJ on Twitter, Instagram, and TikTok. We'll be back next week with a sui generis perspective on the hottest topics in the news related to your civil rights and the criminal injustice system, as well as a discussion of the relationship between the implied consent laws and administrative driver's license suspensions in impaired driving investigations. Erica, my grandfather always told me when we parted ways, don't do anything I wouldn't do. And to that, I add, if you do and you get caught, call me. I'll defend your rights as I'd want mine defended.